Case 1. Wade Willis. A father calls Vermont State Police and tells them his son has killed a girl. He gives the location. He gives her name. His son is 16 years old and is standing in the next room, saying nothing. That is how Case 1 begins. Wade Willis was 16 years old and lived in the rural Northeast Kingdom town of Morgan, Orleans County, Vermont, a community of fewer than 700 residents where the Willis and Weed families were neighbors. Willis attended North Country Union High School in Newport, Vermont, alongside his girlfriend, 15-year-old Terry Weed. Court records established that Weed was pregnant at the time of her death and that Willis was the father. The pregnancy had become known among students at the school. Testimony entered at trial documented that Willis was subjected to taunting by classmates in the period leading up to May 21, 1981. On the afternoon of May 21, Willis was at the home of his cousin, Roy Bullis, in Morgan. Vermont Supreme Court records from State v. Willis, 145 Vermont 459, decided 1985, document what happened next. Willis told Roy Bullis that Weed was pregnant and that he was the father. He then stated that he intended to kill her so that no one would find out. Roy Bullis did not treat the statement as credible at the time. Later that afternoon, Terry Weed was killed in a wooded area near her home. The Orleans County Medical Examiner determined the cause of death was blunt force trauma. A baseball bat and a shovel were recovered at the scene by Vermont State Police. Within hours, Vermont State Police received a sequence of 4 telephone calls. The first 2 were anonymous, reporting only that a killing had occurred in Morgan. The third came from Joseph Bullis, Roy's father. The fourth came from Dwayne Willis, Wade's father, who told troopers to come to his residence because his son had killed a girl. State Police Corporals Rivard and Johnson responded. They arrived at the Willis residence and met Dwayne Willis in the kitchen. When asked what had happened, Dwayne Willis stated, and this is in the court record, "My son tells me he killed some girl." He identified the victim as Terry Weed, gave the location of the body, and confirmed his son was 16. Willis was standing in the adjacent living room. When officers asked for him, he walked in. He said nothing. Wade Willis was arrested and charged with first-degree murder. He was processed as an adult under Vermont law, which at that time set 16 as the threshold age for adult prosecution in serious felony cases. He was arraigned in Newport, entered a not guilty plea, and was held without bail. The trial commenced in Orleans County Superior Court in late March of 1982. Defense attorney Duncan Kilmartin did not contest the fact that Willis had caused Weed's death. The defense strategy was an insanity defense under Vermont Statute 13 VSA Section 4801, combined with a diminished mental capacity claim. Kilmartin presented psychiatric testimony and argued that social pressure and bullying at school had produced a mental state in which Willis was unable to appreciate the criminality of his conduct. The prosecution's central witness was Roy Bullis, 17 at the time of trial. Bullis testified to the conversation that had taken place earlier on the afternoon of the killing, the conversation in which Willis had stated his intention to harm Weed. That testimony established premeditation, which was the critical element for the first-degree murder charge. The jury rejected the insanity defense and returned a verdict of guilty on first-degree murder in April of 1982. On May 18, 1982, Willis was sentenced to 10 years to life in prison. He appealed to the Vermont Supreme Court. In 1985, the Supreme Court issued its decision in State v. Willis and upheld the conviction, finding no reversible error in the trial court's instructions on the insanity standard or in the admission of evidence. Willis served over 19 years in custody. In 2001, he was released on furlough. He was placed in a residence in White River Junction, not in the Northeast Kingdom, specifically in recognition of the wishes of Terry Weed's family, who continued to live in the Newport area. The case remains part of Vermont Supreme Court published case law and is cited in subsequent decisions addressing the insanity defense and diminished capacity claims. It was also one of 2 1981 Vermont cases involving teenage defendants that together produced a special legislative session and a fundamental revision of the state's juvenile statutes. That second case is next. Like this video if you are finding value in this episode. Subscribe to Cold Justice for new episodes every week. Let's keep going. Case 2, Lewis Hamlin 3. The state of Vermont had the statutory framework to prosecute one of the 2 defendants. It did not have the framework to prosecute the other. One received a sentence of 45 years to life. The other was released at 18. That legal outcome produced 30,000 petition signatures and a special session of the Vermont legislature. Case 2. On May 15, 1981, 6 days before the Willis killing in Morgan, two 12-year-old girls named Melissa Walbridge and Megan O'Rourke left their school in Essex Junction, Vermont, in the late afternoon. They took a wooded shortcut through a recreational area on their route home. Both girls were attacked in that wooded area. Melissa Walbridge died from her injuries. Megan O'Rourke survived. The individuals responsible were identified as Lewis Hamlin III, 16 years old, of Burlington, Vermont, and James Savage, 15 years old, of Essex Junction. O'Rourke's survival was the critical evidentiary factor. Within approximately 1 week of the attack, investigators compiled photographic lineups. O'Rourke reviewed the photographs and selected 2 images, identifying Hamlin and Savage. Both were arrested. Forensic corroboration supported the identification. Investigators documented that in the immediate aftermath of the attack, a person matching the description of one of the assailants had removed facial hair. James Savage's mother told investigators that her son had returned home that evening and asked her to cut his hair, then proceeded to shave his beard himself. O'Rourke had noted in her account that one of the individuals had a short growth of facial hair. That detail, volunteered by a family member, connected the physical description to the suspect's post-incident behavior. A pellet gun used during the attack, described in court records as having been obtained by Savage and given to Hamlin, was addressed in the prosecution's filings. Footwear trace evidence at the scene was also a subject of testimony at trial, establishing which footwear type corresponded to which defendant, with testimony from prosecution witnesses that Hamlin typically wore boots and Savage wore sneakers. Chittenden County State's Attorney Mark Keller prosecuted. He charged Hamlin with first-degree murder and aggravated sexual assault. The trial of Lewis Hamlin III was held in Windsor County Superior Court in the spring of 1982. The venue had been moved from Chittenden County due to the degree of public attention the case had generated, in order to address concerns about jury impartiality. Megan O'Rourke, now 13, testified for the prosecution. Her testimony was composed and specific. She maintained her identification of both attackers throughout cross-examination. Defense attorney Orest Valsangiacomo challenged certain aspects of her testimony and argued that the physical evidence was more consistent with Savage, not Hamlin, having administered the fatal injury to Melissa Walbridge. The prosecution countered with the accomplice liability standard, that even if Hamlin had not personally administered the fatal wound, his willing and active participation from the beginning of the assault made him legally responsible for the outcome. State's Attorney Keller made the legal standard explicit in closing argument. If Hamlin and Savage were in it together from the start, the verdict was guilty. The jury agreed. Hamlin was convicted of first-degree murder. He was sentenced to 45 years to life in prison, with a concurrent sentence of 15 to 25 years on the sexual assault conviction. Now for the element of this case that changed Vermont law. James Savage was 15 at the time of the assault. Under Vermont's juvenile statute as written in 1981, an individual under the age of 16 could not be charged as an adult regardless of the nature of the offense. The law provided only that such an individual could be adjudicated delinquent through juvenile court. The maximum consequence was detention in juvenile custody until the age of majority. Savage was held in juvenile detention for approximately 3 years and released at 18. The contrast between the two outcomes was immediate and public. 2 Vermont residents organized a petition drive. Approximately 30,000 signatures were gathered across the state. The petition demanded that the legislature convene in special session to address what the public viewed as an unacceptable gap in the law. The Vermont legislature responded. In special session, lawmakers amended the juvenile statute, creating a framework under which individuals as young as 10 years old could be charged as adults for serious and heinous crimes, depending on the severity of the offense. The categorical age threshold that had protected Savage from adult prosecution was eliminated. Lewis Hamlin III served his sentence initially at St. Albans Correctional Center in Vermont. Institutional records document that he was subsequently transferred to a federal correctional facility in Springfield, Missouri, after Vermont corrections officials determined that his presence in the state prison population created administrative safety concerns that could not be adequately managed within a state facility. Hamlin appealed his conviction following sentencing. The Vermont courts reviewed and upheld the conviction under the accomplice liability standard. Those appellate decisions are part of the published record. Following his release from juvenile detention, James Savage relocated. Publicly documented accounts from the period indicate that he changed his legal name and moved out of state. His juvenile record was protected by statute, and his subsequent life occurred outside Vermont's jurisdiction. The Walbridge case, alongside the Willis case from the same week, remains one of the most significant catalysts for legislative reform in Vermont's criminal justice history. Megan O'Rourke's testimony is studied in law enforcement training contexts as a documented example of a surviving witness whose cooperation and identification produced criminal accountability that would not otherwise have been achievable. Subscribe to Cold Justice. We are halfway through this episode. 3 cases remain. Case 3. Robert Tulloch and James Parker. They had a plan, a budget, and a weapon. The plan had been in development for approximately 6 months. The budget was $10,000. The weapon was ordered online under the purchaser's own name, and that transaction record became the evidentiary thread that connected 2 Vermont teenagers to a double homicide 25 miles from their front door. Case 3. Robert Tulloch was born in 1983. James Parker was born in 1984. Both lived in Chelsea, Vermont, a rural community in Orange County. Both attended Chelsea Public School. By all accounts, they were intelligent, capable teenagers from a quiet Vermont town. According to Parker's later confession, entered into the court record as part of his cooperation agreement with the state of New Hampshire, the two began developing a criminal plan in approximately 2000. The plan originated with a goal. They wanted to leave Vermont and move to Australia. They estimated they needed $10,000 to do so. The method they settled on was methodical. They would approach homes that appeared to be owned by affluent individuals. They would present themselves as students conducting environmental surveys in order to gain entry. Once inside, they would restrain the occupants, compel them to provide credit card and ATM information, including personal identification numbers, and then kill the occupants before leaving. Parker's account documented that they attempted to execute this scheme at 4 or 5 other homes in Vermont and New Hampshire over approximately 6 months in 2000. At each prior attempt, no one was home or the occupants did not permit entry. The plan was never successfully executed at any prior location. In early January of 2001, Parker purchased 2 SOG military-style knives through an internet retailer. He made the purchase under his own name. He provided his Chelsea, Vermont address. The transaction was completed and the knives were shipped. On January 27, 2001, Tulloch and Parker drove from Chelsea, Vermont, to Etna, New Hampshire, approximately 25 miles. They approached the residence of Half and Suzanne Zantop on Trescott Road. Half Zantop was 62 years old and a professor of earth sciences at Dartmouth College. Suzanne Zantop was 55 years old and chair of the German Studies Department at Dartmouth. They had been married since 1970 and had 2 adult children. Tulloch and Parker knocked on the door. They identified themselves as students conducting an environmental survey. Half Zantop allowed them inside. Both Half and Suzanne Zantop were killed at the scene. The cause of death for both, as determined by the New Hampshire medical examiner, was multiple stab wounds. New Hampshire State Police responded that evening and processed the scene. The crime scene investigation produced 2 categories of critical physical evidence. First, fingerprints recovered from inside the residence were matched through comparison to James Parker. Second, a knife sheath recovered at or near the scene was identified as matching the SOG knife model. Investigators traced the sheath type to the manufacturer's product line and then issued a subpoena to the online retailer. The records returned under that subpoena identified James Parker, with his Chelsea, Vermont address, as having purchased 2 SOG knives of the relevant model in early January of 2001, approximately 3 weeks before the killings. Deputy Medical Examiner Thomas Gilson examined identical knives and compared them to the wound characteristics documented in both autopsies. His expert report concluded that the wounds on both victims were consistent with having been produced by the SOG knife model Parker had purchased. The weapon type matched the forensic findings. Investigators traveled to Chelsea. Both Parker and Tulloch were interviewed without arrest. Parker told investigators he had purchased knife sheaths to build a fort and had later sold them. Tulloch also declined to provide information useful to the investigation. Before arrest warrants were formally executed, both teenagers left Chelsea. Their disappearance in February of 2001 triggered a multi-state fugitive investigation involving New Hampshire State Police, Vermont State Police, the FBI, and law enforcement agencies along the corridor from New England to the Midwest. They were located at a truck stop in Indiana. Both were taken into custody without incident and returned east to face charges. At the time of the crimes, Parker was 16 and Tulloch was 17. Both were charged with first-degree murder in the deaths of Half and Suzanne Zantop under New Hampshire law. Parker entered into a cooperation agreement with the New Hampshire Attorney General's office. In exchange for testifying against Tulloch and providing a full account of the planning and execution of the crime, he pleaded guilty to one count of accomplice to second-degree murder in the death of Suzanne Zantop. He was sentenced to 25 years to life. He served close to the minimum term and was released on parole in June of 2024 at the age of 40. Tulloch had initially indicated through his legal representation that he might pursue an insanity defense. His attorneys conducted a psychiatric evaluation process during the pretrial period. He ultimately chose not to pursue that defense and entered guilty pleas to 2 counts of first-degree murder, 1 count for each victim. He made no public statement of remorse at the plea proceeding. He was sentenced to 2 consecutive terms of life in prison without the possibility of parole. Tulloch has spent more than 2 decades in custody challenging his sentence. His central legal argument is that sentencing a juvenile offender to life without parole is unconstitutional. His efforts were supported by the United States Supreme Court's decisions in Miller v. Alabama, decided in 2012, and Montgomery v. Louisiana, decided in 2016, both of which addressed the constitutionality of mandatory life without parole sentences for juvenile offenders. In July of 2025, a Grafton County Superior Court judge issued a 32-page opinion holding that life imprisonment without the possibility of parole for juvenile offenders is inconsistent with the New Hampshire state constitution. Under that ruling, Tulloch, then 41 years old, became eligible to seek resentencing. That ruling addresses eligibility for consideration, not any guaranteed outcome. Robert Tulloch remains incarcerated. The 2001 Dartmouth murders are documented in law enforcement training materials and academic criminology literature as one of the early cases in which internet transaction records played a decisive evidentiary role. Parker's online purchase, made under his own name with his own address, was retrievable by subpoena. The digital commerce record provided the link between the purchased weapon and the crime scene that fingerprint evidence alone had already begun to establish. The case is a documented example of how commercial data and forensic pathology can be combined to build an evidentiary foundation in a homicide investigation. Leave a comment below. We want to hear from you on these cases. Subscribe if you have not already. 2 cases remain. Case 4. Hussein Mohammed. 4 teenagers are sitting in a parked car outside a Bristol, Vermont apartment at 7:20 in the evening. A loaded 9mm handgun is being passed between them. When the gun fires, the 14-year-old in the front seat is hit. A neighbor rushes out to perform CPR. The boy dies at the University of Vermont Medical Center. The defendant, also 14 years old, tells the victim before emergency responders arrive, "I didn't mean to shoot you." Case 4. Hussein Mohammed. Bristol, Vermont. October 30th, 2023. Vermont State Police and local officers responded to a report of a shooting at 120 North Street near Plank Road in Bristol, Addison County. Officers arrived to find 14-year-old Madden Gouveia of Shelburne in a critical condition inside a sedan parked in the driveway of a residential property. A neighbor had already initiated CPR. Emergency personnel transported Gouveia to the University of Vermont Medical Center in Burlington, where he was pronounced dead. On November 2, 2023, the Chief Medical Examiner's Office in Burlington completed an autopsy. The cause of death was determined to be a gunshot wound to the torso. The manner of death was ruled a homicide. The defendant, Hussein Mohammed, was 14 years old and a resident of Burlington. A court affidavit filed in Addison County Superior Court documented the sequence of events. Gouveia had a 9mm Smith & Wesson handgun in the vehicle and had been passing it between the four occupants. Court records noted that some individuals in the car were waving the firearm and loading and unloading it. Mohammed was holding the weapon when it discharged, striking Gouveia in the back. An 18-year-old who was also present in the vehicle was a key witness. He told police that after the firearm discharged, Mohammed stated to Gouveia, "I didn't mean to shoot you." That statement was entered into the court record as reported witness testimony. The 18-year-old then removed Gouveia from the vehicle and placed him on the ground before the neighbor came out and CPR began. The investigation produced a significant complication. State police court documents noted that at least 2 eyewitnesses from inside the car initially provided investigators with false accounts of what had occurred, including a claim that the shooting had been a drive-by, meaning that a gunman outside the vehicle had fired in. Physical evidence and subsequent witness re-examination contradicted this account entirely. The forensic evidence established that the shot had been fired from within the car, not from outside. The false accounts were eventually corrected through the investigation. Addison County State's Attorney Eva Vicos announced that her office would charge Mohammed as an adult. Under Vermont's revised juvenile statute, the law amended following the 1981 cases, defendants aged 14 and older charged with specified serious felonies, including murder, could only be charged in adult court. Mohammed faced 3 counts: second-degree murder, involuntary manslaughter, and aggravated assault. Vermont law sets the maximum penalty for second-degree murder at 20 years to life in prison. Mohammed was arraigned on October 31, 2023, the day after the shooting, in Addison County Superior Court in Middlebury, at the Judge Frank G. Mahdi Courthouse. He appeared before Judge David Finster. His public defender, Jonathan Heppel, entered a not guilty plea on his behalf. Mohammed's parents and 3 brothers were present in the courtroom. The state requested that Mohammed be held without bail in a correctional facility. State's Attorney Vicos cited the severity of the alleged conduct, prior conditions of release Mohammed had allegedly violated, and the need to protect the community. However, Vermont no longer had a functioning secure juvenile facility. The Woodside Juvenile Rehabilitation Center had been closed approximately 4 years earlier, in 2019, and had not been replaced. There was no facility in Vermont capable of holding young defendants charged as adults in the juvenile detention context. After Vicos withdrew her detention request, declining to present supporting evidence after Judge Finster ruled he would not close the courtroom, Finster released Mohammed to the custody of his parents under strict conditions. Those conditions included a 24-hour curfew, with narrow exceptions for school, medical appointments, therapy, and court appearances. He was prohibited from contacting any of the individuals who had been present in the vehicle at the time of the shooting or their family members. The case generated 2 distinct lines of public debate in Vermont. The first concerned the appropriateness of adult charges for a 14-year-old in a case where the defendant's own statement, "I didn't mean to shoot you," appeared in the court record as an expression that the discharge was unintentional. The Rutland NAACP issued a public statement expressing concern that the adult charging decision reflected an instinctive punitive response rather than a careful assessment of the facts, and raised questions about whether racial bias had influenced the decision. State's Attorney Vicos maintained that the conduct was sufficiently severe to warrant adult court proceedings. She stated publicly, "The behavior, as far as we're concerned, was reckless to an extreme, and someone's dead because of it." The second line of debate concerned Vermont's complete absence of a juvenile detention facility. The Gouveia family, including the victim's father Richard Gouveia and his sister, spoke publicly about the need for Vermont to establish a permanent secure facility. The family acknowledged in public statements that Madden Gouveia and Mohammed had been involved together in car break-ins in the weeks prior to the shooting, and that a judge had previously ordered them not to have contact with each other. Despite that order, both had been present in the same vehicle on the night of October 30th. Mohammed's legal team filed a motion to transfer the case to Vermont's family court system, where proceedings would be protected from public access. The state's attorney's office opposed the transfer, arguing the seriousness of the conduct required adult court jurisdiction. In June of 2024, the transfer was granted. The case moved to family court. Once transferred, Vermont's family court confidentiality statute shielded the proceedings from public documentation. 7 Days Vermont, which had previously published Mohammed's name and photograph, removed both from its digital coverage following the transfer, citing a June 2024 editorial policy against identifying juveniles in most criminal cases. The final court disposition of this case is not publicly documented. What is fully in the public record is the following. 14-year-old Madden Govia of Shelburne died from a gunshot wound to the torso on October 30, 2023, in the driveway of a North Street property in Bristol, Vermont. The medical examiner ruled his death a homicide. Hussein Mohammed, also 14, was publicly identified in adult court proceedings, charged with second-degree murder, manslaughter, and aggravated assault, and represented in those proceedings before the case was transferred to family court jurisdiction in 2024. The case also stands as one of Vermont's clearest documented examples of the gap between statutory charging authority and institutional infrastructure. Vermont's law allows adult prosecution of young defendants for serious crimes. Vermont had no facility to hold them. That gap, exposed in real time by this case, became an active legislative and policy issue that the Vermont government was still working to address as of the time this episode was produced. Hit subscribe now if you have not already. Final case up next. Case 5, Mohammed said. Just before 6 in the evening on the coldest kind of Vermont winter day, a 911 caller reports a black Cadillac SUV parked behind an elementary school with a bullet hole in the window. A person is slumped in the driver's seat. Officers arrive at 510 Portland Street and find 38-year-old Christina Chatloss unresponsive. She is pronounced dead at 6:04 in the evening. It is Vermont's first documented homicide of 2024. The suspect is 15 years old. Case 5. Mohammed said. St. Johnsbury, Vermont. January 23, 2024. Vermont State Police detectives and St. Johnsbury police officers responded to the scene on Portland Street, on the grounds of the Cornerstone School. The vehicle, a 2023 black Cadillac XT4 SUV, was located partially against an embankment behind the school building. The caller had reported a bullet hole visible in the passenger side window. Officers confirmed that Christina Chatloss, 38, of Williamstown and Barre, Vermont, was in the driver's seat. She was pronounced dead at the scene at 6:04 in the evening. State Police Corporals George Johnson and Stephen Hartwell documented the scene. Press photography published by the Caledonian Record newspaper, St. Johnsbury's daily paper and one of Vermont's oldest, captured a bullet hole visible in the windshield of the Cadillac at the scene. On January 25, 2024, the Chief Medical Examiner's Office in Burlington completed an autopsy. The cause of death was determined to be a gunshot wound to the torso. The manner of death was ruled a homicide. Vermont State Police detectives pursued the investigation through the days that followed. The evidentiary record documented in the court affidavit filed in Vermont Superior Court in Caledonia County identified the suspect as Mohammed said, 15 years old, a resident of Springfield, Massachusetts, and a native of Maine. According to the affidavit, the encounter between Said and Chatloss on the evening of January 23 was connected to a drug transaction involving crack cocaine. Documentation indicated that following the transaction, a dispute arose, reportedly over Said's cell phone, which Chatloss was alleged to have refused to return. Witness testimony referenced in court records indicated that before the firearm was discharged, one of the individuals present stated an intention to kill Chatloss, who was seated inside her vehicle. Said was identified as the individual who fired the weapon. Said was not immediately taken into custody in Vermont. In the immediate aftermath of the shooting, he was detained in Vermont on an unrelated warrant from the state of Massachusetts. He was extradited to Massachusetts and held in juvenile custody there while the Vermont homicide investigation continued. Vermont State Police detectives continued building the evidentiary record during this period. On February 26, 2024, Massachusetts State Police arrested Said in Springfield on the Vermont murder warrant issued by Caledonia County. Vermont State Police issued a public statement confirming the arrest. Said was identified publicly by the Caledonia County State's Attorney's Office because the case was being filed in adult court in Vermont. His name appeared in the Vermont Superior Court affidavit filed in Caledonia County. On March 4, 2024, Mohammed said appeared before a Vermont judge, appearing virtually from a secure facility in Massachusetts, and entered a not guilty plea to the charge of second-degree murder. He was being charged as an adult under Vermont's statutory framework. Vermont's second-degree murder carries a maximum sentence of 20 years to life in prison. The Caledonia County State's Attorney's Office initiated extradition proceedings to return said from Massachusetts to Vermont for the continuation of court proceedings. As reported by the Boston Globe and the Caledonian Record, said was one of two individuals present at the scene on the evening of January 23. The identity and disposition of the second individual was not publicly addressed in the available documentation. The case carried dimensions beyond the individual facts of the incident. Vermont law enforcement officials and prosecutors stated publicly that teenage defendants arriving from out of state, particularly from the Springfield, Massachusetts corridor, were becoming an increasingly documented pattern in Vermont violent crime cases. A January 2025 investigative report by WCX Television documented what reporters described as a crime corridor between Vermont and Massachusetts. According to WCX reporting, between 2022 and 2024, 28 of Vermont's 74 documented homicides involved either a suspect or a victim from out of state. Vermont State Police also addressed the broader context of rising homicide numbers in the state. According to the WCX investigation, Vermont's homicide figures had risen from a low of 64 drug overdose and violence-related deaths in 2014 to figures approaching those last recorded in the late 1990s. Vermont Governor Phil Scott and the Vermont legislature both cited public safety as a priority legislative issue in 2024, specifically referencing the rise in violent incidents across the state. The case of Christina Chatloss generated significant attention in the St. Johnsbury area. The Caledonian Record, which maintains Vermont's oldest continuous daily news record in the Northeast Kingdom region, reported extensively on the investigation and prosecution. Members of Chatloss's family gave public statements. Her brother Bill Chatloss spoke to WCX as part of the January 2025 Crime Corridor investigation, describing his sister as someone who had faced personal struggles but who had remained close to her family. Her mother Marilyn Chatloss told the Boston Globe that Christina was a very loving, caring daughter who would help anyone. In early 2025, the Caledonian Record reported that the state was actively opposing a defense motion to transfer said's case to juvenile court. Defense counsel had argued that the proceedings should be handled within the juvenile system rather than in adult criminal court. The Caledonia County State's Attorney's Office filed in opposition, maintaining that the nature of the alleged conduct, a 15-year-old charged with fatally shooting a 38-year-old woman in a school parking lot following a drug transaction, warranted adult court jurisdiction. As of the time this episode was produced, no trial date had been publicly reported and no verdict had been issued. The case was in active litigation in Caledonia County Superior Court. What is fully established in the public record? Christina Chatloss, 38, of Williamstown and Barre, Vermont, died from a gunshot wound to the torso on January 23, 2024, in the parking lot of the Cornerstone School at 510 Portland Street in St. Johnsbury, Vermont. The chief medical examiner ruled her death a homicide. Mohammed said, 15 at the time of the offense, was publicly identified through adult court proceedings filed in Caledonia County Superior Court. He was arrested on a Vermont murder warrant in Massachusetts, arraigned virtually in Vermont Superior Court, charged as an adult with second-degree murder, and entered a not guilty plea. The matter was actively contested in court as of production of this documentary. 5 cases, 5 defendants. Over 4 decades of Vermont court proceedings, from 1981 through 2024. Each case in this episode is drawn from the public record. Every charge, every court appearance, every verdict and sentence referenced here can be verified through the sources named. No speculation has been presented as fact. No detail has been added beyond what the documented record supports. Vermont's experience across these decades shows a justice system in continuous revision, adjusting its juvenile statutes when public pressure demanded it, applying evolving constitutional standards as the courts develop them, and still working, in the most recent cases, to close the gap between what the law authorizes and what the institutional infrastructure can actually deliver. If this episode gave you value, please like this video now. Drop a comment telling us which case stood out to you or which state you want covered next. Subscribe to Cold Justice and hit the notification bell so you never miss a new episode. This has been Cold Justice. The record speaks for itself. Like, comment, subscribe.